If you own a home with your spouse, your child, or your business partner, you probably think that if something happens to you, they automatically get the house. No courts, no lawyers, no fuss. Well, I hate to break it to you, but a lot of the time, that is completely false. I've been a practicing attorney for over 25 years, and I've seen countless families get caught completely off guard, dragged into nightmare court battle, all because of two missing words on their property deed. Today I'm going to show you exactly how to check your own deed to see if you're exposed to this trap, the hidden legal landmines that could trigger a family feud, and the gold standard way to protect your home so it never touches a courtroom. Let's look at a quick story to see how this plays out in real life. Meet Dick and Jane. They bought a beautiful home together, and they assume everything is fine. In their minds, if Dick passes away, Jane automatically owns the whole house and life moves on. Then the unthinkable happens. Dick dies. A few weeks later, Jane is sitting in the probate attorney's office, absolutely blindsided. She just found out that half of her own home is now frozen in the probate court process. Why? Because their deed was missing or three specific words if they were married, husband and wife, or tenants by the entirety for four words. When you buy property, how you take title matters just as much as whose name is on the paper. If your deed explicitly says joint tenants with rights of survivorship, you're in the clear for that specific asset. When one owner dies, the survivor automatically absorbs the other half of the property. No probate, no judge, it's clean transfer. But if those words aren't there, in many states, the law defaults to treating it and the parties' relationship as tenants in common. Because Dick and Jane's deed didn't specify survivorship, Dick's 50% share didn't go to Jane. It went to his estate. And if all Dick had was a standard will or no plan at all, that means probate court. Now Jane owns her half, but she has to ask a judge for permission to deal with Dick's half. That is how families end up in court by accident. Now you might be thinking, well, my spouse and I love each other, and our kids are great, so probate will just be a minor, expensive speed bump, right? Not necessarily. It gets much uglier if you have a blended family, kids from a prior marriage, or unexpected financial hurdles. Let's say Dick had children from a previous marriage. Under a tenants in common default, Dick's 50% share might not even go to Jane. By law, it could be split between Jane and his kids from his first marriage, or it might go directly to the kids if Jane and Dick were not married. Now, Jane is an accidental co-owner of her home with her adult stepchildren. If you want to sell the house, everyone has to agree. If one of those kids goes through a divorce or a bankruptcy, a creditor could put a lien on Jane's house. That is exactly why I tell people, do not do your own deeds. Quick claim deeds look incredibly simple online. You download a form, fill in the blanks, and think you're a legal mastermind. But real estate law is incredibly picky. Miss the exact phrase required by your specific state, and you're signed a ticking time bomb. The worst part, you won't discover the mistake when you sign it. Your family will discover it after you're gone when it's too late to fix it. But let's take it a step further. Let's say you check your deed and it does say joint tenants or tenants by the entirety. Are you totally safe? Honestly, you've only avoided one specific trap. Relying solely on the deed is like putting a Band-Aid on a broken arm. The ultimate payoff and the absolute best way to handle your real estate is to own your house through a living trust or a specialized realty trust. Here is why a trust completely outperforms the standard deed. Number one, it gives you incapacity protection. A deed only tells us who gets the property when you die. But what if you suffer a stroke or dementia and are alive but incapacitated. If you're joint tenants, your spouse cannot sell or refinance the house without your signature, meaning they have to go to court to get a guardianship. A trust appoints a successor trustee to step in seamlessly without a judge being involved, so the transfer could be very easy. The other thing that a trust does is privacy. See, deeds in probate court cases are public record. Anyone can look up what your house is worth and who inherited it. A trust is a private document. What you own and who gets it stays your business. And you also get some control from the grave. A trust allows you to say, Jane gets to live in the house for the rest of her life, but when she passes, the remainder goes to our children. A deed cannot do that. Good estate planning isn't just about avoiding a single court trap. It's about making sure your home, likely your biggest asset, is handled exactly how you want it during your life. If you get sick, at your death, and for the generation that follows. So here is your homework for the week. Pull out your property deed. Look at the language. If you don't see the words joint tenants with rights of survivorship, or tenants by the entirety, or husband and wife, and if you aren't 100% sure what your state's specific laws require, do not leave it to chance. Have somebody take a look at it. Dick and Jane thought they were perfectly fine until probate court proved otherwise. Don't let your family learn the hard way. Let's look at your deed together, look at your family dynamic, and build an ironclad plan, whether that's a deed correction or a comprehensive living trust that keeps your business out of the courts. If you want to learn how to avoid probate, join us in the next video that will provide you with 3 strategies to avoid the probate process. I'll see you over there.